Labor Law Review Part 2. Labor Standard. Employer-employee relationship. Concept, Article 1700 and CC. Article 1700. The relations between capital and labor are not merely contractual. They are so impressed with public interest that labor contracts must yield to the common good. Therefore, such contracts are subject to the special laws on labor unions, collective bargaining, strikes and lockouts, closed shop, wages, working conditions, hours of labor and similar subjects. The two-tiered test in determining employment relationship economic dependency, two-tiered test. This two-tiered test would provide us with a framework of analysis, which would take into consideration the totality of circumstances surrounding the true nature of the relationship between the parties. This is especially appropriate in this case where there is no written agreement or terms of reference to base the relationship on, and due to the complexity of the relationship based on the various positions and responsibilities given to the worker over the period of the latter's employment. Francisco v. NLRC, GR number 170087, August 31, 2006. Elements. 1. The punitive employer's power to control the employee with respect to the means and methods by which the work is to be accomplished, fourfold test. 2. The underlying economic realities of the activity or relationship, economic reality test. The fourfold test, control test. The fourfold test in labor law. In determining the existence of employer-employee relationship, the elements that are generally considered comprises the so-called fourfold test, namely: A. The selection and engagement of the employee. B. The payment of wages. C. The power of dismissal, and D. The employer's power to control the employee with respect to the means and methods by which the work is to be accomplished. It is the so-called control test that is the most important element. Notes: 1. It is important to determine whether an employment relationship exists because this has an effect on the applicability of the labor code. 2. Generally, if there is employer-employee relationship, the labor code applies. Hence, labor courts have jurisdiction. Also generally, if there is no employment relationship, the labor code does not apply and labor courts have no jurisdiction. 3. Selection and engagement refers to the choice of the employer to hire the services of a worker and his commitment to keep the latter as his employee. 4. Payment refers to the compensation that an employee gets for a work performed. 5. Dismissal is a component of the employer's power to move or organize employees. It is a management prerogative whom to hire and or fire. Dismissal is an act of labor force movement done by the employer that results in the termination of employment relationship. However, it must be noted that, for purposes of the labor code, simply because the disputants stand not in the proximate relations of employer and employee does not mean that there is no labor dispute. In fact, a worker dismissed from employment is still an employee under the law until and unless his dismissal is declared valid and final by proper authority. Source: projectjurisprudence.com. The Economic Reality Test. The Economic Realities Test seeks to determine whether, as a matter of economic reality, the worker is reliant on the hiring party to earn a living, employee, or is self-reliant and independent, contractor. Retrieved from whoismyemployee.com. Under the broader economic reality test, the petitioner can likewise be said to be an employee of Respondent Corporation because she had served the company for 6 years before her dismissal, receiving check vouchers indicating her salaries, wages, benefits, 13th month pay, bonuses and allowances, as well as deductions and Social Security contributions from August 1, 1999 to December 18, 2000. When petitioner was designated General Manager, Respondent Corporation made a report to the SSS signed by Irene Ballesteros. Petitioner's membership in the SSS is manifested by a copy of the SSS specimen signature card which was signed by the President of KSI Corporation, and the inclusion of her name in the online inquiry system of the SSS evinces the existence of an employer-employee relationship between petitioner and Respondent Corporation. Francisco v. NLRC, GR number 170087. Cases: the Manila Hotel Corporation vs. NLRC. Facts: in May 1988, Marcelo Santos was an overseas worker in Oman. In June 1988, he was recruited by Palace Hotel in Beijing, China. Due to higher pay and benefits, Santos agreed to the hotel's job offer, and so he started working there in November 1988. The employment contract between him and Palace Hotel was, however, without the intervention of the Philippine Overseas Employment Administration, POEA. In August 1989, Palace Hotel notified Santos that he will be laid off due to business reverses. In September 1989, he was officially terminated. In February 1990, Santos filed a complaint for illegal dismissal against Manila Hotel Corporation, MHC, and Manila Hotel International, Limited. MIL. The Palace Hotel was impleaded but no summons were served upon it. MHC is a government-owned and controlled corporation. It owns 50% of MIL, a foreign corporation, Hong Kong. MIL manages the affair of the Palace Hotel. The labor arbiter who handled the case ruled in favor of Santos. The National Labor Relations Commission, NLRC, affirmed the labor arbiter. Issue: whether or not the NLRC has jurisdiction over the case. Held: no, the NLRC is a very inconvenient forum for the following reasons. 1. The only link that the Philippines has in this case is the fact that Santos is a Filipino too. However, the Palace Hotel and MIL are foreign corporations. AMHC cannot be held liable because it merely owns 50% of MIL, it has no direct business in the affairs of the Palace Hotel. The veil of corporate fiction can't be pierced because it was not shown that MHC is directly managing the affairs of MIL. Hence, they are separate entities. 3. Santos' contract with the Palace Hotel was not entered into in the Philippines. 4. Santos' contract was entered into without the intervention of the POEA. Had POEA intervened, NLRC still does not have jurisdiction because it will be the POEA which will hear the case. 5. MIL and the Palace Hotel are not doing business in the Philippines. Their agents, officers are not residents of the Philippines. Due to the foregoing, the NLRC cannot possibly determine all the relevant facts pertaining to the case. It is not competent to determine the facts because the acts complained of happened outside our jurisdiction. It cannot determine which law is applicable. And in case a judgment is rendered, it cannot be enforced against the Palace Hotel. In the first place, it was not served any summons. The Supreme Court emphasized that under the rule of forum nonconveniens, a Philippine court or agency may assume jurisdiction over the case if it chooses to do so, provided 1. That the Philippine court is one to which the parties may conveniently resort to. 2. That the Philippine court is in a position to make an intelligent decision as to the law and the facts. 3. That the Philippine court has or is likely to have power to enforce its decision. None of the above conditions are apparent in the case at bar. Joe vs. NLRC. Labor Standards. A. Existence of employer-employee relationship. Facts: private respondent working as a barber on piece-rate basis was designated by petitioners as caretaker of their barbershop. Private respondent's duties as caretaker, in addition to his being a barber, were 1. To report to the owners of the barbershop whenever the air condition units malfunction and or whenever water or electric power supply was interrupted. 2. To call the laundry woman to wash dirty linen. 3. To recommend applicants for interview and hiring. 4. To attend to other needs of the shop. For this additional job, he was given an honorarium equivalent to 1/3 of the net income of the shop. Private respondent left his job voluntarily because of his misunderstanding with his co-worker and demanded separation pay and other monetary benefits. Petitioners contends that respondent was not their employee but their partner in trade whose compensation was based on a sharing arrangement per haircut or shaving job done. Issue: whether or not there exists an employer-employee relationship. Held: yes. In determining the existence of an employer-employee relationship, the following elements are considered: 1. Selection and engagement of worker. 2. Power of dismissal. 3. The payment of wages. And 4. The power to control the worker's conduct, with the latter assuming primacy in the overall consideration. The power of control refers to the existence of the power and not necessarily to the actual exercise thereof. It is not essential for the employer to actually supervise the performance of duties of the employee. It is enough that the employer has the right to wield that power. Republic vs. Asia Pro Cooperative, GR. Number 172101. Facts. Respondent Asia Pro Cooperative is composed of owners members with primary objectives of providing them savings and credit facilities and livelihood services. In discharge of said objectives, Asia Pro entered into several service contracts with Stanfilco. Sometime later, the cooperative owners members requested Stanfilco's help in registering them with SSS and remitting their contributions. Petitioner SSS informed Asia Pro that being actually a manpower contractor supplying employees to Stanfilco, it must be the one to register itself with SSS as an employer and remit the contributions. Respondent continuously ignoring the demand of SSS, the latter filed before the SFC. Asia Pro alleges that there exists no employer-employee relationship between it and its owners members. SSC ruled in favor of SSS. On appeal, Court of Appeals reversed the decision. Issue: whether or not there is employer-employee relationship between Asia Pro and its owners members. Held: yes. In determining the existence of an employer-employee relationship, the following elements are considered: 1. The selection and engagement of the workers, 2. The payment of wages by whatever means, 3. The power of dismissal, and 4. The power to control the worker's conduct, with the latter assuming primacy in the overall consideration. All the aforesaid elements are present in this case. First, it is expressly provided in the service contracts that it is the respondent cooperative which has the exclusive discretion in the selection and engagement of the owners members as well as its team leaders who will be assigned at Stanfilco. Second, it cannot be doubted then that those stipends or shares in the service surplus are indeed wages, because these are given to the owners members as compensation in rendering services to respondent cooperative via client, Stanfilco. Third, it is also stated in the above-mentioned service contracts that it is the respondent cooperative which has the power to investigate, discipline and remove the owners members and its team leaders who are rendering services at Stanfilco. Fourth, in the case at bar, it is the respondent cooperative which has the sole control over the manner and means of performing the services under the service contracts with Stanfilco as well as the means and methods of work. Also, the respondent cooperative is solely and entirely responsible for its owners members, team leaders and other representatives at Stanfilco. All these clearly prove that, indeed, there is an employer-employee relationship between the respondent cooperative and its owners members. Insular Life Assurance Co., Limited vs. NLRC and Militia Bajau, GR. Number 88484, Facts. Petitioner Insular Life entered into a contract with respondent Bajau where the latter is authorized to solicit for insurance policies. Sometime later, the parties entered into another contract which caused Bajau to organize an agency in order to fulfill its terms. The contract being subsequently terminated by petitioner, Bajau sued the latter, which prompted also for the termination of their engagement under the first contract. Bajau thus filed before the Ministry of Labor seeking to recover alleged unpaid commissions. Petitioner contends that Bajau is not an employee but an independent contractor for which they have no obligation to pay said commissions. The labor arbiter found for Bajau, ruling that there exists employer-employee relationship between him and petitioner. NLRC affirmed. Issue: whether or not employer-employee relationship existed between petitioner and Bajau. Held: no. In determining the existence of employer-employee relationship, the following elements are generally considered, namely, 1. The selection and engagement of the employee, 2. The payment of wages, 3. The power of dismissal, and 4. The power to control the employee's conduct. Although the latter is the most important element, it should, however, be obvious that not every form of control that the hiring party reserves to himself over the conduct of the party hired in relation to the services rendered may be accorded the effect of establishing an employer-employee relationship between them in the legal or technical sense of the term. Rules and regulations governing the conduct of the business are provided for in the Insurance Code and enforced by the Insurance Commissioner. It is, therefore, usual and expected for an insurance company to promulgate a set of rules to guide its commission agents in selling its policies that they may not run afoul of the law and what it requires or prohibits. None of these really invades the agent's contractual prerogative to adopt his own selling methods or to sell insurance at his own time and convenience, hence cannot justifiably be said to establish an employer-employee relationship between him and the company. The court, therefore, rules that under the contract invoked by him, Bajel was not an employee of the petitioner, but a commission agent, an independent contractor whose claim for unpaid commissions should have been litigated in an ordinary civil action. In contrast to the case decided by the court 10 years after, Insular Life Assurance vs. NLRC and Pantaleon de los Reyes. Tonko vs. Manufacturers Life Insurance Company Incorporated, GR. Number 167622. Facts, taking from the November 2008 decision, the facts are as follows. Manufacturers Life Insurance Company is a domestic corporation engaged in life insurance business. Tadios was its president and chief executive officer. Petitioner Tonko started his relationship with Manulife in 1977 by virtue of a career agent's agreement. Pertinent provisions of the agreement state that it is understood and agreed that the agent is an independent contractor and nothing contained herein shall be construed or interpreted as creating an employer-employee relationship between the company and the agent. A. The agent shall canvass for applications for life insurance, annuities, group policies and other products offered by the company, and collect, in exchange for provisional receipts issued by the agent, money due or to become due to the company in respect of applications or policies obtained by or through the agent or from policyholders allotted by the company to the agent for servicing, subject to subsequent confirmation of receipt of payment by the company as evidenced by an official receipt issued by the company directly to the policyholder. B. The company may terminate this agreement for any breach or violation of any of the provisions hereof by the agent by giving written notice to the agent within 15 days from the time of the discovery of the breach. No waiver, extinguishment, abandonment, withdrawal or cancellation of the right to terminate this agreement by the company shall be construed for any previous failure to exercise its right under any provision of this agreement. C. Either of the parties hereto may likewise terminate his agreement at any time without cause, by giving to the other party 15-day notice in writing. Sometime in 2001, Tadios addressed a letter to Tonko, then one of the Metro North managers, regarding meetings wherein Tadios found Tonko's views and comments to be unaligned with the directions the company was taking. Tadios also expressed his concern regarding the Metro North manager's interpretation of the company's goals. He maintains that Tonko's allegations are unfounded. Some allegations state that some managers are unhappy with their earnings, that they're earning less than what they deserve and that these are the reasons why Tonko's division is unable to meet agency development objectives. However, not a single manager came forth to confirm these allegations. Finally, Tadios related his worries about Tonko's inability to push for company development and growth. Tadios subsequently sent Tonko a letter of termination in accordance with Tonko's agent's contract. Tonko filed a complaint with the NLRC against Manulife for illegal dismissal, alleging that he had an employer-employee relationship with Tadios instead of a revocable agency by pointing out that the latter exercised control over him through directives regarding how to manage his area of responsibility and setting objectives for him relating to the business. Tonko also claimed that his dismissal was without basis and he was not afforded due process. The NLRC ruled that there was an employer-employee relationship as evidenced by Tadios's letter which contained the manner and means by which Tonko should do his work. The NLRC ruled in favor of Tonko, affirming the existence of the employer-employee relationship. The Court of Appeals, however, set aside the NLRC's ruling. It applied the fourfold test for determining control and found the elements in this case to be lacking, basing its decision on the same facts used by the NLRC. It found that Manulife did not exert control over Tonko, there was no employer-employee relationship, and thus the NLRC did not have jurisdiction over the case. The Supreme Court reversed the ruling of the Court of Appeals and ruled in favor of Tonko. However, the Supreme Court issued another resolution dated June 29, 2010, reversing its decision. Tonko filed a motion for reconsideration, which is now the subject of the instant case. Issue: whether the Supreme Court erred in issuing the June 29, 2010 resolution, reversing its earlier decision that an employer-employee relationship existed. Held: no, the Supreme Court finds no reason to reverse the June 29, 2010 decision. Control over the performance of the task of one providing service both with respect to the means and manner, and the results of the service is the primary element in determining whether an employment relationship exists. The Supreme Court ruled petitioner's motion against his favor since he failed to show that the control Manulife exercised over him was the control required to exist in an employer-employee relationship. Manulife's control fell short of this norm and carried only the characteristic of the relationship between an insurance company and its agents, as defined by the Insurance Code and by the law of agency under the Civil Code. In the Supreme Court's June 29, 2010 resolution, they noted that there are built-in elements of control specific to an insurance agency, which do not amount to the elements of control that characterize an employment relationship governed by the Labor Code. The Insurance Code provides definite parameters in the way an agent negotiates for the sale of the company's insurance products, his collection activities, and his delivery of the insurance contract or policy. They do not reach the level of control into the means and manner of doing an assigned task that invariably characterizes an employment relationship as defined by labor law. To reiterate, guidelines indicative of labor law control did not merely relate to the mutually desirable result intended by the contractual relationship. They must have the nature of dictating the means and methods to be employed in attaining the result. Tested by this norm, Manulife's instructions regarding the objectives and sales targets, in connection with the training and engagement of other agents, are among the directives that the principal may impose on the agent to achieve the assigned tasks. They are targeted results that Manulife wishes to attain through its agents. Manulife's codes of conduct, likewise, do not necessarily intrude into the insurance agent's means and manner of conducting their sales. Codes of conduct are norms or standards of behavior rather than employer directives into how specific tasks are to be done. In sum, the Supreme Court found absolutely no evidence of labor law control. Manila Golf Country Club, Incorporated vs. Intermediate Appellate Court. Facts: Respondent Furman Lammer and his fellow caddies filed with the Social Security Commission for coverage and availment of benefits under the Social Security Act. Subsequently, all but 2 of the original 17 petitioners withdrew their claim for Social Security coverage. The case continued and was adjudicated by the SSC only as regards the 2 holdouts, dismissing their petition and stating that the caddies were never employees of petitioner. An appeal was taken to the IAC, but the other caddies' appeal was dismissed at his instance, leaving Respondent Lammer the lone appellant. The Intermediate Appellate Court found for Lammer, finding employer-employee relationship between him and petitioner. Issue: whether or not Respondent Lammer is an employee of petitioner. Held: no, the various matters of conduct, dress, language, etc. covered by the petitioner's regulations, does not, in the mind of the court, so circumscribe the actions or judgment of the caddies concerned as to leave them little or no freedom of choice whatsoever in the manner of carrying out their services. The court agrees with petitioner that the group rotation system, so called, is less a measure of employer control than an assurance that the work is fairly distributed, a caddy who is absent when his turn number is called simply losing his turn to serve and being assigned instead the last number for the day. In the final analysis, petitioner has no way of compelling the presence of the caddies, as they are not required to render a definite number of hours of work on a single day. Even the group rotation of caddies is not absolute because a player is at liberty to choose a caddy of his preference regardless of the caddy's order in the rotation. It can happen that a caddy who has rendered services to a player on one day may still find sufficient time to work elsewhere. Under such circumstances, he may then leave the premises of petitioner and go to such other place of work that he wishes. Or a caddy who is on call for a particular day may deliberately absent himself if he has more profitable caddying, or another, engagement in some other place. These are things beyond petitioner's control and for which it imposes no direct sanctions on the caddies. Jardinet.tal. Versus NLRC. Facts. Petitioners were drivers of private respondents' taxicabs under the boundary system whose earnings were regularly deducted washing fee for the taxi units. Petitioners decided to form a labor union to protect their rights and interests on the belief that the deductions made were illegal. Upon learning, respondent refused to let petitioners drive their taxicabs when they reported for work. Aggrieved, petitioners filed a complaint for illegal dismissal with the labor arbiter, but the latter dismissed said complaint. On appeal, the NLRC tribunal declared that petitioners are employees of private respondent. On reconsideration, however, the decision was reversed by the NLRC tribunal and held that no employer-employee relationship between the parties exists. Issue: whether or not petitioner taxi drivers are employees of respondent company. Held, yes. In a number of cases decided by this court, we ruled that the relationship between jeepney owners, operators on one hand and jeepney drivers on the other under the boundary system is that of employer-employee and not of lessor-lessee. In the case of jeepney owners, operators and jeepney drivers, the former exercise supervision and control over the latter. The management of the business is in the owner's hands. The owner, as holder of the Certificate of Public Convenience, must see to it that the driver follows the route prescribed by the franchising authority and the rules promulgated as regards its operation. Now, the fact that the drivers do not receive fixed wages but get only that in excess of the so-called boundary they pay to the owner, operator is not sufficient to withdraw the relationship between them from that of employer and employee. We have applied by analogy the doctrine to the relationships between bus owner, operator and bus conductor, autocalaza owner, operator and driver, and recently between taxi owners, operators and taxi drivers. Hence, petitioners are undoubtedly employees of private respondent because as taxi drivers they perform activities which are usually necessary or desirable in the usual business or trade of their employer. Galamba Medical Center, Incorporated versus NLRC, et.al., GR. Number 176484. The Galamba Medical Center, petitioner, a privately owned hospital, engaged the services of medical doctor spouses Ronaldo Lanzanas, Dr. Lanzanas, and Merceditha Lanzanas, Dr. Merceditha, in March 1992 and August 1995, respectively, as part of its team of resident physicians. Reporting at the hospital twice a week on 24-hour shifts, respondents were paid a monthly retainer of 4,800 pesos each. It appears that resident physicians were also given a percentage share out of fees charged for outpatient treatments, operating room assistance and discharge billings, in addition to their fixed monthly retainer. The work schedules of the members of the team of resident physicians were fixed by petitioner's medical director Dr. Raul de Zepeda. And they were issued identification cards 3 by petitioner and were enrolled in the Social Security System, SSS. Income taxes were withheld from them. On March 7, 1998, Dr. Mayus Trinidad, also a resident physician at the hospital, inadvertently overheard a telephone conversation of respondent Dr. Lanzanas with a fellow employee, Diosdado Muscula, through an extension telephone line. Apparently, Dr. Lanzanas and Muscula were discussing the low census or admission of patients to the hospital. Dr. de Zepeda, whose attention was called to the above said telephone conversation, issued to Dr. Lanzanas a memorandum of March 7, 1998 reading: as a licensed resident physician employed in Galamba Medical Center since several of years ago, the hospital management has committed upon you utmost confidence in the performance of duties pursuant thereto. This is the reason why you were awarded the privilege to practice in the hospital and were entrusted hospital functions to serve the interest of both the hospital and our patients using your capability for independent judgment. Very recently, though, and unfortunately, you have committed acts inimical to the interest of the hospital, the details of which are contained in the hereto attached affidavit of witness. You are therefore given 24 hours to explain why no disciplinary action should be taken against you. Pending investigation of your case, you are hereby placed under 30 days preventive suspension effective upon receipt hereof. Inexplicably, petitioner did not give respondent Dr. Merceditha, who was not involved in the said incident, any work schedule after sending her husband Dr. Lanzanas the memorandum, nor inform her the reason therefor, albeit she was later informed by the Human Resource Department, HRD, officer that was part of petitioner's cost-cutting measures. Responding to the memorandum, Dr. Lanzanas, by letter of March 9, 1998, admitted that he spoke with Ms. Kala over the phone but that their conversation was taken out of context by Dr. Trinidad. On March 14, 1998, the rank-and-file employees union of petitioner went on strike due to unresolved grievances over terms and conditions of employment. On March 20, 1998, Dr. Lanzanas filed a complaint for illegal suspension before the National Labor Relations Commission, NLRC Regional Arbitration Board. Dr. Merceditha subsequently filed a complaint for illegal dismissal. In the meantime, then Sec. Cruzenchino Trajano of the Department of Labor and Employment, DOL, certified the labor dispute to the NLRC for compulsory arbitration and issued on April 21, 1998 return to work order to the striking union officers and employees of petitioner pending resolution of the labor dispute. In a memorandum of April 22, 1998, Dr. Dizapita echoed the April 22, 1998 order of the Secretary of Labor directing all union officers and members to return to work on or April 23, 1998, except those employees that were already terminated or are serving disciplinary actions. Dr. Dizapita thus ordered the officers and members of the union to report for work as soon as possible to the hospital's personnel officer and administrator for work scheduling, assignments and/or reassignments. Petitioner later sent Dr. Lanzanas a notice of termination which he received on April 25, 1998, indicating as grounds therefor his failure to report back to work despite the dole order and his supposed role in the striking union. Thus, on April 23, 1998, you still did not report for work despite memorandum issued by the CMC Medical Director implementing the Labor Secretary's order. The same is true on April 24, 1998 and April 25, 1998, you still did not report for work. You are,